Justice Thomas, Justice Alito, Justice Sotomayor, Ms. Kagan.
So what you just said, Mr. Fagan, is one of the confusing parts of this case to me, is that when I read your brief, the formulation of the test that you offer is, could the claim of error have been raised under 2255? And I have some sympathy for why that would be an extremely relevant question, but it just does not seem to be a question that applies in this case. Because here, as you say, we've never said that an actual innocence claim could be raised under Section 2255. So sort of the premise of your argument, which is it could have been raised in 2255, sorry, you lost your chance. But the premise of the argument is it could have. And here we don't really know that it could have. The court has never said whether it could have. So the rule doesn't really seem to fit the case, if you understand what I mean.
Well, 2 points, Your Honor. You might, I think, more usefully use the formulation that it would be a claim that or an asserted reason that attacks the validity of the conviction or sentence, and I think this one would fall into that. And when we talk about Section 2255
So there is a real difference between that formulation and the one you most often give in your brief. So you're now switching from the one you give in your brief to saying, does this attack the validity of the conviction?
Well, we said both in our brief, Your Honor, and to the extent we're focusing on Section 2255 claims, I mean, frankly, that's largely as a result of the court-written question presented that we were trying to work within, which I assume kind of was written in a way the court intended to apply to this case. But the second thing I'd say is, to the extent you would include things that would attack the validity of the conviction or sentence, like a claim of disquiet, that just aren't even substantively meaningful enough to get past the first marker on Section 2255 claim, that's all the worse for prisoners in this position. So I think you would write it a bit more broadly. But I would take something. I would take this as something that could be alleged under Section 2255, and it would simply lose. I think it would make absolutely no sense to have a rule that if you could win or you could have made your claim under Section 2255 and it would be substantively valid, then you're precluded. But if you would have had a substantively invalid claim, you wouldn't be.
Okay, thank you.
Justice Gorsuch, Justice Kavanaugh.
Just so I have the